rise. Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number 1, CACV 16-0710, Patricia Bocchinov versus FountainShadows Homeowners Association. Council, I would remind you that this oral argument is being recorded, so if when you approach the microphone, if you'd please identify yourselves and who you represent. Appellant's counsel, if you watch the clock and reserve any time that you would like for rebuttal, that'll be up to you. Also, please keep in mind that we've read the briefs, so we're familiar with the basic facts and background of the case, and we've also discussed the case in conference. With that, counsel for appellant, you may proceed.
Well, good morning. May it please the court, my name is Chad Meissen, and I'm counsel for the appellant FountainShadows Homeowners Association. The issue before the court is a rather straightforward issue. The question is, did the trial court err in holding that the association was not the prevailing party in the injunction action at the justice court level, and as a result granting Ms. Bocchinov's motion for summary judgment? Simply put, did the association prevail in the injunction action? And the answer is yes, it did, because it received what it was asking for, the injunction. And because it prevailed, the court should recognize the association's claim for fees and costs related to that action, and that it requested, the association requested during Ms. Bocchinov's home sale closing, in which she paid. And that means that the trial court's summary judgment must be reversed and its monetary judgment vacated.
But there was no request, was there, by the Homeowners Association for fees in justice court?
That's correct, Your Honor. The association has very clear CC&R language that indicates or provides that all attorneys' fees and costs incurred in enforcing the CC&Rs, which would include enforcing the behavior restrictions that are included therein, and that the attorney's fees shall be awarded. And so or shall be entitled, I should say. And so the request was not necessary at the justice court level. The association had the right to demand those fees at some point in the future when homeowners sell their homes.
Well, if our statutes and rules of tort require that any award of attorney's fees be arising out of a legal proceeding be addressed, considered, and ordered by the court in that proceeding, how can a standard attorney's fees provision in CCRs authorize what I would call a direct assessment here?
Thank you for the question. If I understand the question, it's really one of sort of, can the association choose not to formally request fees and have those reduced to judgment in a proceeding, and it has the association somehow waived its right to be able to collect those? And I would just say to the court that the contracted issue here, the CC&Rs, don't require that an amount due from an owner, a member of the association, be reduced to judgment for the association to be entitled to them. Now, of course, if there's a dispute as to the amount, then the association, it would go through a standard process where the association, I'll use this, what actually occurred here. If Ms. Bocchinov was contesting the amount that was due, then the process is to seek judicial determination of the amount, whether that's typically before it's paid.
I apologize for interrupting, but let's talk about the amount that was due here. How would Ms. Bocchinov, if I'm pronouncing that correctly, I hope I am, how would she know how much was due when she's served with this order of protection? And nothing in the order says, oh, by the way, we're about to hit you over the head with some fees, too.
Sure. The association keeps an accounting ledger that owners see a balance, every month when they pay their assessments, they'll see an outstanding balance due. It would break out the amount, or certainly they could request that there be detail provided regarding the amount that's due in order to determine if they're going to argue against it or pay it. And so that could have been done at any time.
So here, is there evidence in the record that it was added, this amount was added to the ledger, to her ledger prior, well in advance of the sale of the home?
I believe that the ledger is included as a part of the record. I'm not sure, as I stand here today, if it indicates when that amount was added to the ledger. It's generally contemporaneous. There's a date assigned, on the ledger. It'll indicate a date that it was entered.
Let's assume for argument that she did not, or did not sell the property, and let's talk about what rights the association would have had in your view. Could the association have, A, reduced that to an assessment, B, imposed a lien, recorded the assessment, and C, foreclosed on the assessment?
It's a great question, Your Honor. The Arizona law provides that HOA liens, or that the HOA has a lien for assessments, but it details that those are related to the regular and special assessments, I believe, and attorney's fees for collection of those assessments. Whether or not, I suppose, this would be deemed to, or could be deemed to be an assessment as that's stated under that statute, is perhaps an open question. But the association would have, let's assume that the association doesn't have a lien, that the lien doesn't secure these amounts, just for the sake of argument here, because the association didn't record anything, then the association would have the standard 6-year statute of limitations to seek collection of those amounts if she had never sold her property. But she sold her property relatively quickly, several months later, and so that just never came up. But the amounts were on the ledger.
Understood. But just, okay, going back to, or following up from Judge Gammel's questions, why do we have court rules? And in this particular case, I think we even have a statute that discusses fees for associations. But if we have rules that govern when you request fees, doesn't this contract language, the way you interpret it, doesn't it do an end run around the requirement that a party request fees? Because for analogy, by analogy, I sue you, I loan you money, you don't pay me, I sue you for breach of the promissory note. I better ask for fees, even though the note says that I'm going to be awarded fees. I better ask for them in the action. Wouldn't you agree?
I think that's probably an efficient method, and I think in that circumstance, this contract is, when I talk about this contract, the CC&Rs and the relationship between an HOA and the members is a unique contractual relationship compared to others. Yeah. And in your example, Your Honor, of the promissory note, that's probably going to end the relationship between those parties, where it would make an efficient use of resources and time to request those at that time, because you're going to be collecting on that judgment. In this case, the issue before the HOA, or what the HOA was seeking, was to stop bad behavior, as it viewed it, and to comply with the CC&Rs with an ongoing relationship with the member, because at that time we didn't have any knowledge that she would be selling her property. So the association was focused on obtaining that injunction. And with the very clear language in the CC&Rs regarding attorney's fees, could decide at a later time if it was going to expend resources and time to collect those. But it's our view that that doesn't require that those be reduced to judgment at the time that they're incurred, that they are, in fact, still owed by the member pursuant to the contract between the HOA and the member, that being the CC&Rs, that provides that if the association prevails, that the member is responsible for the attorney's fees and costs, that the association is entitled to all attorney's fees and costs incurred in the action. And so, as the prevailing party, which the trial court determined the association wasn't the prevailing party, and we can discuss that further, which it really doesn't, in our view, coincide or is inconsistent with the case law, because the two bases that the trial court had was, one, that the injunction action was unopposed, and therefore you can't prevail if you don't have some contested action, which, again, contrary to case law, because and noted in our brief, pages 12 through 14 in the appellant's opening brief, that there's no requirement that it be contested. Actions are often not contested, and you would still have a prevailing party. The question is, did they get what they were asking for, if I can paraphrase or summarize it down to that.
I think if the case turned on prevailing party or not prevailing party, I see your argument quite well. You got what you asked for, so in that sense, prevailing. On the other hand, it was uncontested, but she had the opportunity to come in later and contest it and did not, right?
Correct.
Is there anything in the record about her behavior, anything actually factually clear in the record about her behavior after the order of protection?
I don't believe that there is, and the reason is because there wasn't contact after the injunction that I'm aware of.
Seemed to work, but we don't know, unless we could read her thoughts, we don't know why there was no more obnoxious behavior.
Yeah, the association was not in a position where it needed to go back to the court to enforce the injunction order.
And I hate to belabor this, but I'd like to go back. I just want to make sure you're resting on, as I understand it, two or maybe more. I guess that's my question. Two provisions of the CC&Rs. The one that starts out from page 3 of your opening brief: no noxious or offensive activity shall be carried on, and no one should become an annoyance, interfere with the quiet enjoyment, etc. That's the behavior restriction you mentioned earlier.
That's correct, Your Honor.
Okay, and then the attorney's fees provision.
That's correct, Your Honor.
Is there anything else that you're relying on to authorize this direct assessment without going to the justice court and getting an adjudication of fees?
As to the fees, no. It is the language in the CC&Rs that we are resting on, that the association has the right to recover those. It doesn't indicate when the relationship with the parties was continuing. There's certainly a 6-year statute of limitations with regard to collecting those amounts. If she hadn't sold her home, it went through a natural process, which was that she did sell her home. The association was requested to provide a payoff of any outstanding balance through that normal escrow process. It did that, and it was paid.
Was there any procedure that the association went through to formally create a lien on the property?
No, there's an automatic lien pursuant to Arizona law. In this case, because it's a planned community, it would be 3318. 18. Now I'm missing it as I started to cite it. I can find it for you, but
that's quite all right. Although I was going to write it down, but well, I noticed on page 4 of your opening brief, you cite the provision from the CC&Rs about creation of lien and personal obligation, but that looks to me like it's addressing annual assessments or charges and special assessments authorized by the board of directors. So I guess one of my questions that flows from that is whether there was an authorization of the board of directors to impose these fees on Ms. Bocchinov. As a formal special assessment.
Well, Your Honor, of course, what is an assessment? It's not defined under the statute, and all amounts, essentially, if the association is seeking payment of something, that would be an assessment. Now, if there's a dispute as to the validity of those charges and the association's right to those charges, that can be reviewed by the court, and in this case was. But the association does, in fact, assess all amounts due under the under the CC&Rs, which is the governing contract here. And here, Article 17, Section 1, in fact, does provide that the association is entitled to all fees. So that would be an amount that would be properly assessed, again, subject to judicial review should there be a dispute that arises from it. But
it doesn't require action by the board.
Correct.
There was none here that in our record as far as
other than the employment of attorney or attorneys to enforce the specific performance of the provisions in the CC&Rs.
But should the board have entertained a resolution or a motion that says we hereby declare as a special assessment against this homeowner the $3,800, whatever it was?
I suppose it could have. I don't know if that would have any legal impact. The fact is that the CC&Rs provide that it is owed to the association, and if the association is the prevailing party, which again comes back to what the trial court was getting at, and we firmly believe that the association was the prevailing party because it obtained what it requested and got the relief that it was looking for, which is no further harassing or offensive behavior in violation of the CC&Rs. It got that, and it was the prevailing party. This notion that the injunction was somehow enforceable under constitutional scrutiny was a bit puzzling because, in fact, these, as I've mentioned in my brief, these are forms that are vetted and prescribed by the Office of Administration of the Courts, has been used for years and years, and certainly did have quite a bit of specific detail regarding people, addresses. It was narrowly tailored to in time, location, and what conduct, how she could contact individuals, in this case in writing. And so we do believe that it was quite specific. And in fact, the case law bears out that common sense interpretation of the statute is required. So to the extent that the court believed that near wasn't specific enough, that the term near, again, a common sense approach in interpreting the language is appropriate. And that goes also for the court's other point, which was that it, under the court's view, prohibited constitutionally protected conduct, but in fact, it was really the court's hypotheticals could, if it were enforced in a certain way, that would potentially restrict constitutionally protected conduct. But there's no evidence in the record or no evidence whatsoever that, given that the association didn't actually have the need to enforce the injunction, that it would be enforced in a manner that would violate constitutional rights. In this case, it was very clear on what she could and could not do, where she could and could not go, and so long as it wasn't enforced in a manner that restricted her constitutionally protected rights was valid. And so, again, the association was the prevailing party. The CC&Rs provide that it is entitled to all attorney's fees and costs related to that, and so the trial court's holding should be reversed. And if I, with the court's permission, I would like to reserve the remainder of my time for rebuttal.
Okay.
Thank you.
Counsel?
Good morning, Your Honors. May it please the Court. My name is Jonathan DeSalles, and I represent Patricia Bocchinov in this matter. The HOA's position in this case really comes down to the following three statements. First, they were the prevailing party in the injunction against workplace harassment action. Second, they were entitled to fees incurred in the injunction against workplace harassment action. And third, they didn't have to ask for those fees. They could simply collect them at any time they chose. Each of these statements is false.
Why should they have to ask for the fees when the provision says all? We get it all. If there's a quarrel about whether we incurred these, well, okay, we can adjudicate the amount that we actually incurred and paid, but but I don't see that as an issue here.
Because, Your Honor, the injunction against workplace harassment was not an action to enforce the CC&Rs. This case is very much like the Brown versus Teresita case, very much almost identical to the Keystone case. And also the Bennett-Blum case, in which there's a statutory action, and an injunction against workplace harassment action is a statutory action. There's nothing, they don't even mention, except in passing, to say that there happens to be CC&Rs that are subject to the property. If you look at the petition, they don't mention this provision that they now rely on, Section 10 of Article 5 of no noxious or offensive activity. They don't mention that in the injunction against workplace action. If the injunction against workplace harassment action was truly intended to enforce that provision of the CC&Rs, wouldn't you at least mention it? And as
What were there facts alleged in the petition for the injunction?
I don't believe so. Again, I think if you look at the deed restrictions, and if you consider that deed restrictions are intended to impose on personal property, not on behavior, then I think it makes sense. The actions were in the injunction against workplace harassment. She bothered a certain couple people.
Now,
She wasn't.
Are these affidavits that were submitted, or were witnesses called to testify?
These were affidavits, ex parte affidavits. Ms. Bocchinov had no notice of this proceeding, and under the injunction against workplace harassment proceedings, there's a provision for fees, which only kicks in should the person show up consistent with basic ideas of due process. If she doesn't show up, you don't get fees. As Your Honor pointed out in the Keystone case, the HOA could have brought an action for breach of contract. That would have implicated the CC&Rs in that case. They chose, very calculated to do so, they chose to proceed under an injunction against workplace harassment, denying her the opportunity to come in to contest, at least initially, to contest the allegations and to get an order against her.
This provision, excuse me for interrupting, for fees when you're seeking this kind of injunction in justice court, are you referring to a statute or a rule, court procedure rule?
There's both, Your Honor. Under excuse me, under the it's ARS 12-1810 subsection O.
Yes.
That provides for an award of attorney's fees to after notice and the opportunity to be heard. And that's the provision that should have been applied here, much like in, again, the Brown case.
But counsel, didn't she have the opportunity to be heard after it was issued? Couldn't she have simply requested a hearing and she would have had a right to one?
Sure. But at that point, the proceeding's over. Why would you go back into...
Wait, why is it over? It's not over if she requests a hearing.
If she requests a hearing, or she could...
She controlled all the cards. She could have asked for a hearing, and the court would have given her a hearing, had to give her a hearing.
Absolutely. Or she could have said, you know what, I'm done with this place, I'm selling my unit, I don't know why they're doing this to me, I'm out of here. She didn't have, there's no requirement to go in there, and in fact, the reality is with these injunctions against workplace harassment, you don't have to show up. You don't get notice, and you don't have an obligation to come in and challenge it.
I think what you're saying is this is a little bit like a default. If you're sued for $5,000 and you default, maybe you just decide not to answer, but then you're not exposed to default plus $2,500 more for fees.
And that's generally true. The difference, of course, is in a default proceeding, you receive notice.
You do.
Before the judgment. In this case, it's judgment first, then you get notice.
Yeah.
It's a very special statutory construct that the legislature created, and the legislature has said that this set of rules and this statute is going to apply, and they chose that. They could have pursued a breach of contract action. They could have
But if she has the opportunity to request that hearing and come in and litigate all of the issues, right, then what's the prejudice to not having received notice ahead of the hearing?
Well, I suppose there's no prejudice, but it certainly doesn't entitle them to fees under a contractual provision when we're still proceeding under the injunction against workplace harassment. Under that scenario, she comes in, there's a hearing, the judge can then make a determination, am I going to award fees? And the basis for fees he would look at would be ARS 12-1810 subsection O. Unless, I suppose, if they somehow said this was also an action arising out of this contract, and keep in mind, they don't cite in their petition anywhere Section 10, this noxious and offensive activity.
They don't cite or attach the CC&Rs.
They don't. The CC&Rs are truly ancillary. In fact, they're an afterthought. They're an afterthought that was offered only in response to Ms. Bocchinov saying, wait a minute, why are you guys taking money out of my escrow sale?
Isn't the association's argument to your lack of notice concern, isn't their argument that, hey, every homeowner has notice of all these CC&R provisions? They have them, or they're certainly entitled to have them. They ought to have them. They ought to read them. And,
Sure.
And the provisions say if we have to take legal action against you, you pay the fees. Isn't that sufficient notice?
Well, no, Your Honor. First of all, that's not what this provision says in this case. There are some CC&R provisions that say that. This provision is very specific. If we take action to, among other things, to enforce compliance with or specific performance of the terms and conditions of this declaration.
So you're saying that was absolutely not pled? Is that's your point?
That wasn't
That's your
pled.
argument? That wasn't pled in the injunction against workplace harassment
It's a word
proceeding?
Can we just call it injunction? Sorry.
Yeah, in
How about we say
the
the
injunction
injunction
proceeding, it was not pled, it was not identified, it was not an issue in that. It did not become an issue until later when they said, this is why we did that. Well, guess what? You can't, in the default context that you raise, you don't get to sue someone, get a judgment against them that doesn't include fees, walk out of the courthouse and hand them a bill for your attorney's fees. That's not the process that this court, that the Arizona courts have followed for decades. That's not the process. We have a process. When there's a judicial proceeding, the court who handles the judicial proceedings determines fees.
Would this case be different if the board of directors had passed a resolution saying to Ms. I've been saying Bocchinov or Bocchinov, but I think you said something different.
I say it differently every time, and so don't believe what I say.
If I'm mispronouncing it, I certainly do not intend to do so, and intend no disrespect. But what if the board of directors had said, had taken formal action and said in a resolution, and they made sure that she knew about it. In a resolution, they said, we're taking this action to seek an injunction against workplace harassment, etc., from Justice Court to enforce the provisions of the no noxious and offensive activity, etc., paragraph of the CC&Rs.
I think what you're suggesting.
And remember that if we prevail, if we get this injunction, you have to pay our fees.
Well, certainly the record would be a little clearer for the association in that context. But what you're suggesting is that, and if I can read into your question a little bit, is this could this be called a special assessment under the CC&Rs? The answer to that is no. Under Article 4, Section 5 of the CC&Rs, it's very clear as to what can and what cannot be a special assessment. And also, special assessments have to be voted on by the members. And I believe that provision says 2/3 of the membership. So no, they could not do that, although that would at least give them a factual basis to hang their hat on, rather than coming into this court and saying after the fact, well, of course we prevailed in that action. Again, they skipped a step. The step they skipped was to go into the Justice Court and ask for fees. Under any provision, a request for fees. There's not even a request for fees in the petition. There's nothing.
So how soon does she find out that attorney's fees are being assessed?
She finds out, I believe she finds out, and I'm not sure if this is in the record, but I believe she finds out literally at the escrow table.
I thought there was something in the record suggesting she hired an attorney to contest those fees before escrow closed. Maybe I dreamed that up.
And I might be misremembering, and if I am, I apologize. I hope I'm not that lawyer she hired, because then it would be even. But
I'm kind of guessing it wasn't you.
well, but the reality, Your Honor, is even if she learned about these fees, there's a process that has to be followed. We don't let parties decide for themselves fees. We let courts decide fees, and that's always been the rule. We don't let, when there's a lawsuit involved, parties make requests for fees, courts award fees. We don't let the prevailing party, a party who thinks they're the prevailing party, pursue an action. I take issue with the characterization of them being called the prevailing party. But I don't think we get to that step. Again, using the sports analogy, if I hold a race against Lance Armstrong and I don't invite Lance Armstrong and I win the race, did I prevail against Lance Armstrong? I don't think I did.
What about if you invited him and he didn't show up?
If I invited him and he didn't show up, then there's an argument that I might have prevailed. Although, even again, as the trial court found, the word prevailed has a context to prevail over some sort of opponent. And if you look at the cases that are in the default context under 12-340-101, which of course is not before us today, but in those cases, when we talk about successful parties, this court has very clearly said 12-340-101 does not apply in a default context. So now, and I think that there's a key distinction, and I'll go back to the Brown case, the Bennett-Blum case, and the Keystone case, because I think this case is a natural progression from those three cases. The key distinction is that each of those cases involved a lawsuit. Each of those cases involved a request for fees. Each of those cases involved a court determining entitlement to fees.
I meant to ask both of you and the question of whether there was any case on all fours with this fact pattern.
I think it's Keystone.
Do you?
I think it's Keystone, Your Honor. I also think it's Bennett.
I thought you just said that in that case they did request fees from the initial court proceeding.
They did, and Your Honor said no. Your Honor said that's a statutory proceeding. If they wanted to bring a breach of contract action to implicate 12-340-101 in that case, they could have done so. Also on all fours with this case is the Brown case. In the Brown...
I think I remember a little bit about that one.
Yes. But in the Brown case as well, Brown was also a case that arose out of a special statutory proceeding that was pursued. Mr. Brown, I believe, did not prevail. The association said, well, we get attorney's fees under the contract, we get attorney's fees under 12-340-101, and this court said no. This court said that's a statutory proceeding, and the rule we look at to determine whether there's an entitlement to attorney's fees rests on the statute itself. We don't look at the contract when the contract is really ancillary or even tertiary to the issue being litigated. The association in this case could have pursued Ms. Bocchinov for an injunction in a regular court case saying she's in violation of the CC&Rs. They chose not to do so. Had they done so, they could have requested an award of attorney's fees. They did not do so.
Well, they could have done that in justice court, couldn't they?
Well, I don't think you get an injunction in justice court. I think that exceeds justice court's jurisdiction. But they could have pursued, I guess, an action for damages if they had one in justice court. But no, I think the limited jurisdiction of justice court would say you're not allowed to pursue and get an injunction in a contract dispute in justice court.
Okay, but you are allowed to get this kind of an injunction.
Which actually raises, which dovetails back to the issue here. They're in justice court. They're saying that they are pursuing an action to enforce compliance with the CC&Rs in a court that, but for the injunction against workplace harassment, can't give the relief under a contract claim. It's very clear, it's explicit in the American rule that Arizona follows that attorney's fees are only available where there's a contract or a statute that authorizes them. Implicit in that rule, but I think equally obvious, is the idea that a party must be awarded fees in order to collect them from an adverse party.
Do you have any case that says that?
I have every case that I've looked at, and every rule, including Rule 54G, the McDowell Mountain versus Simons case, every case, wagon seller, every case in which there's an award of attorney's fees involves a request and involves an award before a collection. This is
Right. I haven't come across a case that was like this in that there was a collection attempted without having requested in the initial legal proceeding the fees.
collection completed before there's even a request for fees. And even after the collection, there's not a fee request made. Ms. Bocchinov has to go file her own lawsuit to say, wait a minute, you took my money without ever going to court, without ever getting an award. Courts serve and I think what's recognized in the McDowell Mountain Ranch case especially, which in McDowell Mountain Ranch, the court said a fee provision that says all fees, even in that context, the courts serve a crucial function. And the crucial function in that case is, even if the fee provision says all fees, the courts still look at them to see whether those fees are clearly excessive. The court serves a crucial function in the adjudication of the reasonableness and the entitlement to attorney's fees. We don't let litigants make that determination for themselves outside of the court. And that's what happened here, and that's improper. Unless Your Honors have any further questions,
I do, counsel.
Yes.
I have a question. So then the association's position is that the award of attorney's fees, or rather the attorney's fees that they assessed, that they imposed, could only be overcome by an evidentiary showing by Ms. Bocchinov that they were obviously excessive. And so your position is that that proceeding could not have been held in the justice court where the injunction had been originally issued? Am I understanding that?
If they had requested the fees, that process would have taken place in the justice court.
But they didn't.
But they
so
didn't.
If she had wanted to challenge those fees as obviously excessive, where do you think that could have been done?
There's no forum for that.
Why couldn't it have been done in her superior court action?
Well, I suppose it could have, but the reality is that's putting the onus on the party who has not requested the fees, who's actually had the fees both just taken from her, to file a lawsuit. That you shouldn't have to do that. You shouldn't have to file a lawsuit to say you improperly took fees from me. So I don't think there's any proper forum for that adjudication to take place. And I think also going back to your question, I think that in terms of her burden, I think again you have to look at the statute, not the CC&Rs, because the statute is what governs an award of fees in an injunction against workplace harassment action.
All right. So your position is that she could not have gone back to the justice court to have those fees determined in terms of whether they were excessive or not?
That is correct.
Okay. All right. Thank you.
Thank you, counsel.
So why don't we begin with that question? Where would Ms. Bocchinov have gone to have a determination made as to whether or not the attorney's fees were excessive?
Well, I think that in the trial court here, that could have been done. We didn't get to that point because the court had determined on summary judgment that the association wasn't the prevailing party. But I believe that the court certainly could have efficiently determined whether or not, if the association was entitled to these fees under the contract, which we argue they are, that then, well, what is the amount? Is it all? Does she has the ability to litigate that issue and to determine what standard it should be litigated under.
So as a matter of course, if a member is taken to justice court, or if there's an injunction issued in justice court where the member has not participated, they've not had notice, and then the attorney's fees are assessed unilaterally by the association, then the proceeding by which they contest is by filing an action in superior court?
I suppose she has a couple of different options. She could have contested the injunction action in the justice court, and the attorney fee issue may have come up there. Or if it didn't, then she could contest it in some other venue, such as the superior court, by filing an action to have it determined. And in fact, to answer one factual discrepancy, to clarify, in fact, in the record, it does reflect that Ms. Bocchinov did have an attorney contact the HOA in July of 2015. I'm not sure who the attorney was, but nonetheless, she was provided in July of 2015 with copies of the attorney's fees and costs that were being sought. So there was notice at that time that in fact the association was assessing her in effect for those fees and costs.
Go ahead.
Could I ask you the same question I asked Mr. DeSalles? Is there any case you know of here or elsewhere in which this sort of direct assessment without getting a court award has been done and upheld? Or addressed?
Yeah, not that I'm aware of, Your Honor. But I think that it may be perhaps because, I'll give you an example of where this can happen. So a mortgage company receives a payoff, someone's selling a home. And at one point in time, that borrower was delinquent in payment of their mortgage. So there might be other fees and costs that are assessed there, and the mortgage company is going to send a payoff to the escrow company. It's going to include all of those fees and costs. They have not been reduced to judgment, but certainly the homeowner has the right to contest that. There's a process for that. They can go to the courts and have that determined. I see that my time is up, so I thank you.
Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement and issue a decision in due course. Court will take a break for a couple minutes to prepare for the next argument.